Hello guys, welcome to LawPutra YouTube channel, and our today's topic is internal aids in interpretation of statutes. First of all, we need to see as to what is statute. It is the will of the legislature. What the lawmakers, that is the legislative assemblies, maybe parliament or state assemblies, they have in their mind what is the will, what is their wish, that is called as the statute. This definition is given by Maxwell. Also, it is also known as the edict of the legislature, and this definition is given by none other than Supreme Court of India in the very famous judgment, that is Vishnu Pratap Sagar Works Limited versus Chief Inspector of Stamp, Uttar Pradesh. Now, when we consider statute, we need to know what are the parts of statute, and there are 16 parts generally, typically they are contained in statute. First is the long title, second is the preamble, third is the short title, fourth is the commencement and extent clause, fifth is the headings, then sixth is definition or interpretation clause, seventh is the operative sections, eighth is the marginal notes, 9 is provisos. Also, on 10th is the explanations, then illustrations, then procedural provisions, and then exceptions and saving clauses, provisions regarding delegated legislation, repeal and amendment, and finally schedules. So these 16 are the typical parts of any statute that we can find when we consider any act, any enactment, any statute. Now let us see what is meant by interpretation, which is synonymous with the construction of any statute. And Salmon has given this definition. He said it is the process. When we say interpretation, it is the process by which the courts, remember, the interpretation of statutes has been entrusted to the courts. The courts seek to ascertain what? The meaning of the legislature, and through the medium of authoritative forms and in which it is expressed. So remember, it is a process. It is meant to ascertain meaning in which it is expressed. So this definition is given by Salmon. We need to know that these parts of the statute, these 16 parts that we have seen, they can also at times aid in and operate as internal aids for interpretation of statutes. Let us see what are those parts and what role they play in interpretation. First part is the long title. As we know, it is just a heading of a statute and it describes its object or purpose. And this is the reason why this long title is important, because it says an act to and do this and do that. Second part is the preamble. It is not considered as the enacting part, because it is the preface to the statute, and it expresses these three things: scope, object, and purpose. Why this statute has been enacted. So this is the preamble. But it is also considered as a key to open minds of act makers. What the act makers had in their mind while they enacted such a statute. But remember, even if any preamble is not considered as the part of enactment, the exception is preamble of our constitution. And because it is considered as a part of the constitution, this is the only exception, because preamble of constitution furnishes a key to open mind of its makers, constitution makers. It is the power given to the legislature through Article 368 Parliament, which can amend the constitution, but this power is limited because this power through Article 368 did not enable to the Parliament to alter the basic structure of constitution, which is given in the preamble itself. So preamble of constitution is the only exception which is considered as part of the constitution. And any doubt related to any article given in the constitution, if we want to interpret it or if we want to clear that doubt, we need to refer to the preamble of that constitution. Then next is the short title. It is considered as the nickname of a statute, short title, and it serves no role. What we can know just by knowing the nickname of any statute, nothing. Then comes the commencement and extent clause. We all know it gives as to when the statute has been made applicable. The effective date is given. And as we all know, typically all statutes, they do not have any retrospective effect except certain given exceptions. And applicability of such statute from the date and in the territories. But of course, after removal of Article 370, Jammu and Kashmir was earlier exception, now it is not with the 2019 Act. Next comes are the headings. Headings, it is a condensed name which is assigned to indicate collectively characteristics of subject matter which are dealt with by enactment underneath. Sometimes they are prefixed to section or sometimes they are prefixed to group or set of sections. This we need to remember. These are meant to giving a key to interpretation of clauses and they are ranged under it unless wording is inconsistent with such interpretation. So this is the importance of headings in statute, or the headings can only be referred to when words of statute are ambiguous, which is rarely a case, but then headings play the part. If we see headings, they are prefixed to section or entries, then they cannot control the plain words of that particular provision. But they cannot be referred to for purpose of construing provision. When words used in provision are clear and unambiguous, only in case of any ambiguity, unclarity, we need to refer to the headings. They cannot be used for cutting down plain meaning of words in provision. Also, in case of any ambiguity or doubt, these headings may be referred to. So this is the role of headings in interpretation. Next comes is the definition clause or interpretation clause, and typically section 2 or clause 2, it considers the definition clause. The legislature has got the power to define certain words, expressions artificially, and this is essential to avoid necessity of frequent repetitions in describing all subject matters to which it is intended to apply. So we need to refer to this clause, interpretation or definition clause, when we need to know the definition or meaning of any particular word or expression used in throughout the statute. It also means to extend the natural meaning of some words as per definition. It also means to assign meaning to words, meanings of which may not be clear. Throughout the statute, if any word is used for which the meaning is not clear, we need to refer to this clause. When they are defined, it may be restrictive of ordinary meaning or it can even be the extensive. And if not defined, then it will be the court's duty to expound its meaning in accordance with what? Stated principles of statutory provision. Next comes is important is the non-obstante clause. Whichever clause, whichever section, subsection starts with the word notwithstanding, it is called as the non-obstante clause. And this is the example. Notwithstanding anything contained in this section, this act, whatever is given or provided for afterwards. It is meant for giving the enacting part of section an overriding effect over provision or act mentioned in clause in event of conflict. And legislative device, non-obstante clause, and it is to modify ambit of provision of law when mentioned and to override it in specified circumstances. So this is the non-obstante clause. It also plays important role. Then comes the marginal notes. As we all know, they are printed at side of sections. They summarize the effect of section and they are not inserted by legislators or under their instructions, but it is the creation of the draftsman, and that is why they cannot be used as aid. This is the only thing. And in case of Constitution of India, these marginal notes, this is the exception, they can be considered as its part as passed by Constituent Assembly and they can be used as aids. So this is the only exception for marginal notes. Then comes the provisos. provided that, provided further that, provided also that. So these are all the provisos. They are typically added to an enactment to qualify or create what? An exception to what is in the enactment. Whatever is provided in any section, the exception to it is given with the proviso. And ordinarily they are not interpreted as stating a general rule, but for the presumption, the enacting part of section would have included in subject matter of provision. Provisos, it has got four purposes: may qualify or accept certain provisions, may change the concept or intendment of enactment, or it may be so embedded in itself to become integral part of enactment to acquire tenor and color of substantive enactment itself. And the fourth purpose is it may be used merely to act as optional addenda to enactment, an object of explaining real intendment of the statutory provision. Then comes the explanations. Typically these explanations are added to the provision. Meaning of particular provision, maybe section or maybe the provisos, and to remove the doubts which might creep up in its absence. If the explanation is not given, then there may be raised any doubt. So just to clear that doubt, these explanations have been given. That does not expand the meaning of provision, but only tries to remove what? Confusion. Explanations, the objects are to explain the meaning of intendment, to clarify any obscurity or vagueness in main enactment, to make it consistent with dominant object it seems to subserve. They provide the additional support to dominant object of act to make it more meaningful, more purposeful. They cannot interfere with or change enactment of any part thereof, but to suppress the mischief, to advance object of act, to assist the court in interpreting true purport and intendment of enactment. Remember, the statutes have been enacted by legislature, but their interpretation has been entrusted to the courts. And they cannot take away the statutory right with which any person under a statute has set at naught the working of act by becoming hindrance in its interpretation. The explanations are important. Illustrations, typically we see especially those statutes which have been enacted in the British era or pre-independence era, we can say. We can find many illustrations to explain provisions of law which have been set out in section. They form part of section. Any illustration given under any section, it is the part of section itself. But that particular illustration cannot form the part of the statute, remember. They are of relevance and value in construction of text of that section only and should not be readily rejected as repugnant to that section. Then comes the exceptions and saving clauses. They say exceptions, they are generally added for exempting something which would otherwise fall within the ambit of the main provision. And saving clauses, they will usually appended in cases of repeal and reenactment of a statute. Typically the amended statute or amendments made, and in case of any inconsistency between main part and saving clause, the main part will prevail. This will be secondary. Saving clause will be secondary. And lastly, what comes is the schedules. And schedules, they are part of statute, but they are meant only for convenience. They may contain substantive enactments. They may even go beyond the scope of the section. And how claims or rights under that act are to be asserted, or with how powers conferred under the act are to be exercised. So this has been given in the schedules. And they may contain some subjects in the form of a list, as in the case with Constitution of India, to lay down the areas in which union and the states can legislate. What we can see, the concurrent list, state list, and union list or main list. So with this, we come to the end of this presentation, internal aids in interpretation of statutes. Thank you.